According to that, in subsection 4B, what I am not to determine today are the property or legal rights of the parties or to restrict other legal remedies of any party. Now, I'm satisfied that I've heard a number of arguments today to indicate to me that there are future decisions that will need to be made in terms of the legal rights of the parties with everything that's been mentioned here. And so, again, I'm not making legal decisions on everything that's been raised before me today. What I am making a decision about is what's under 4A, that I may only determine whether a document is a wrongful lien. The document that I am to determine is whether or not is a wrongful lien is the notice of intent, the pertinent notice of intent. And I do find that that constitutes a wrongful lien, and that is by the court applying the statute 389-102, subsection 12C. Specifically, the notice of intent here does not mention the check. It mentions an option agreement. The option agreement is not signed by the petitioner. There's no contract. There's no pertinent contract, as has been emphasized. And that's the concern of the statute of frauds not being complied with here. But importantly, I've heard here the arguments from a respondent that the signed check by the petitioner should satisfy the statute, subsection 12C. I am deciding here that the signed check is not sufficient to satisfy the notice of intent, where the notice of intent does not mention the check, but mentions only the option agreement. And again, that is not signed. That is not signed. So therefore, in applying subsection 12C of the pertinent statute, I do find that the circumstances of this case indicate that the notice of intent constitutes a wrongful lien. Because of that, what I am also doing is declaring that notice of intent void at this point, releasing the property from that notice of intent, ordering that no additional respondent shall not do any additional liens on the pertinent property. And my understanding, Mr. McDonald, is that in terms of costs and any sort of fees related to this, you're asking that the court address that at a later time. Did I understand that correctly?
Yes, Your Honor. I would like something on the record as to whether or not we're going to be awarded fees, but then the actual amount, I think, could be adjudicated at a further time.
So according to the statute, it says that following a hearing, the court determines that the recorded document is a wrongful lien, the court shall issue in order declaring the wrongful lien void ab initio, releasing the property for lien, and awarding costs and reasonable attorney fees to the petitioner. That statute is very clear. I shall award the costs and reasonable attorney fees to the petitioner. So I'm awarding that. Just the amount of that is for a later date, based upon the petitioner filing what have been the reasonable attorney fees and costs associated with this. And so I'll look for that. And all right. And so I believe that is the scope of the issues for this matter that I needed to decide regarding the petitioner's petition to nullify lien. Mr. McDonald, I'm going to ask you to do the same that I did in the last motion, which is I'm going to ask you to submit an order for my signature that reflects my ruling today, and certainly, first of all, providing that, first of all, to Mr. Beckett. Since you'll be drafting that order, do you have any questions for me about my order?
Yes, Your Honor. I actually have two. Number one, you mentioned actually, I take that back. You did cite this, didn't you? I will prepare an order pertaining to a more formal order. Does the court want to have just one order for both of this? Because I'm assuming that we'll need a document that's going to be recorded against in the county records. Does the court want a shorter one that just says it's released, or does the court also want all the recitation of what you just decided also in the document to be recorded?
That's a great question. Why don't you have, I think we need something that's a little bit longer that fleshes out what I've said, but then a separate document that doesn't have all the details. Mr. Beckett, do you want to be heard on that? I'm just thinking we need something short and simple for what's recorded, but in terms of the details, do you need that fleshed out?
I have lots of questions, Your Honor, that I'd like to have addressed on the record about the court's ruling. If that's if this is the time to address that, I'm happy to do so. Or if you would just like me to tell you whether or not I think a short order as part of the separate half of the case, I can tell you that.
Let's start with this second part, and then certainly I'll come back to you to have you ask the questions you have.
I believe that there need to be two separate orders entered by the court. The second one can be as short as an order that indicates that this is a wrongful lien and pursuant to the court order. I think that would be sufficient.
And let's do that. Were you able to hear that answer?
I'm sorry, could you say that?
The two separate orders, one can be very brief, that it's a wrongful lien.
Your Honor, I prepared a document in anticipation of that. Could we go ahead and do it now?
Would you show that to Mr. Beckett?
May I approach?
Yes. And can I hear any response here, Mr. Beckett?
To this proposed order?
Correct.
My only interest is, Your Honor, is that it is my expectation to file an appeal on this, and that for this notice of interest to be entered, we'd also request an order staying any enforcement or removal of that notice of interest as my client's money is attached. Further, the court entered an order orally that said that a check is insufficient, or at least as far as this goes, because the notice of interest doesn't refer to the check. It refers to an option agreement, but that the court also further went on to say that we cannot record any other notice of interest specifically referencing the check if we prepared a notice of interest that said, well, there's a check that was cashed on X and X day for $225,000 that records our interest. The court has effectively stripped my client of the benefit of that money. And so the court's order today undermines their very ability to protect those proceeds and doesn't even give us an opportunity to perfect our appeals rights. Specifically further is that we would be appealing whether or not this court has subject matter jurisdiction anyway. So this order of the court should hold off until we have an order from an appellate court that determines whether or not this court's decision on the motion that it had just granted earlier, specifically denied earlier, was actually entered correctly. And I do believe that issue will go up to the United States Supreme Court because it was the issue specifically punted by Justice Gorsuch in Skagit Valley. And if that is the case, this court will have effectively eliminated my client's ability to protect her interests or their interests in this real property in a meaningful way. Okay. And those are all very real issues that this court, I believe, needs to take into consideration moving forward on these orders, and I haven't had a full opportunity to review this order yet.
So Mr. Beckett, you certainly have the ability to exercise appellate rights here. What you need is a final order to appeal from, though. And so what I'm looking at is the final order. I'm looking at an order, and I don't have an order. I've not signed an order yet in this. What I've done is given my rulings and indicated that I need an order for my signature, an order that if you and your client can choose to appeal or not choose to, but you need a final order. And so what I'm looking for, the question that was given to me is the nature of that final order before me, and what was offered here is this. Now, I can pause here so you can have a moment to read that. But Mr. McDonald, are you asking that this be the order that I signed to reflect my ruling here today?
Well, I think everyone agreed that there needs to be two orders, one that's more fleshed out. This would be the short one to be recorded in the county recorder's office. Correct.
And so that's what I'm looking at, is the order to be recorded in the county's office. I'm looking at this one. And do I understand, Mr. McDonald, you're asking that this be the order that I sign?
That's correct, yes.
And let me pause here. I've heard Mr. Beckett say he hasn't had an opportunity to read it. I'm going to pause here to give you that opportunity, Mr. Beckett. And if you can indicate to me then if you have any requests to a change on this order.
Your Honor, may I ask a quick question?
Yes.
The version of yours, does it include, paragraph 4, does it say, begin with respondents and its agents, representatives assigned?
Correct.
Okay.
As to the subject of the order with respect to 6, as far as I can recall, and I haven't had an opportunity to go back and listen to the court's order, it seems like it meets with what the court entered verbally, orally. Without being able to look back at that, I wouldn't be able to say 100% if it's correct.
So number 6 is all other issues in this matter, including the award of attorney fees and costs, are reserved for further action by this court. That does reflect, first of all, I'm following the statute, which is that now that I've determined there's a wrongful lien, the statute says I shall award costs and reasonable attorney fees to the petitioner, but in terms of the amount, that is reserved for future. So that, to that extent, it would be accurate. Are you wanting it to flesh out that I've awarded petitioner the amounts?
No. Well, I mean, I haven't had a whole lot of opportunity to look at it and compare. What I'm saying is that the court says that it shall issue an award for attorney's fees.
That's not the statute.
I understand that. The order says all other issues in this matter will be reserved. The court did say that it would issue or award attorney's fees. Again, I think that those two things are not the same, reserved and shall order attorney's fees. Now, the amount to be determined could come at another time, but reserving the issue, that's not been reserved. The court entered an order. That's what I'm saying. I'm very literal when I read things. And as I read this order, it did not literally reflect the court's order on attorney's fees and costs. Literally, the court said shall order and will order, not will reserve it.
And I've heard your concerns. Mr. McDonald.
Your Honor, I'll be preparing a separate order that will be emphatically state that there is an award of fees. The court is going to award fees, which shall be determined at a later date. What I was trying to do here was just be as brief as possible.
Correct.
The fleshed out one will include the court's order, and that will be part of the further action by this court.
Okay. So, Mr. McDonald, you're emphasizing that this is for purposes of what's recorded with the county, and that there's a second order that's contemplated that fleshes out more of the details. Do I understand that correctly?
Yes, ma'am.
Okay. Do you want to be heard on anything else about that?
Yes, Your Honor. I don't think that it would be appropriate to have two different orders in that regard. I was understanding the court before. I was understanding the court before that would be merging the two different motions into a single order. I believe that they should be separated. I did not also believe that the second order should be separated out into two orders. I believe that they should be subsumed into one, so that all of the issues are addressed, so that it's a clear record, because I believe the court got it wrong.
I understand that.
So at that point, I need a clear record that I can appeal from, and if I have one order that's going to go, I don't know, and be recorded down at the county recorder's office, and then something that's going to come later, I don't think that that's appropriate.
Mr. McDonald, would you like to be heard on that? The concern is two different orders, and there's a request that it be one order.
Well, Your Honor, there's no constraint on the court issuing multiple non-final orders. I think it's unnecessary to include a whole bunch of additional verbiage in a recorded document.
And I agree with you, Mr. McDonald.
Okay.
And so I'm viewing the final order, the appealable order, as the one that I'm asking to flesh out in detail what I've indicated are my findings. And this is this would be the order that goes to the county that indicates what I have ordered here today, lifting the lien in essence, or lifting the notice of intent. So that matches here.
Okay.
Here. And I think, let me ask you this. Can you submit the order, the fleshed out order of my findings? Can you submit that within the next 14 days? I can hear that there's a timing concern here of that happening soon after this order, and so would that be sufficient time for you?
That would be fine. Yes, Your Honor, I can do that.
Okay, very good. All right, and so what I'm going to do here is I'm going to go ahead and sign this order and date it today, and with the expectation this is not my final order on this case, because my final order will be drafted by you, Mr. McDonald, and if you'll also give that to Mr. Beckett for his review and then submit that to me.
Okay. Your Honor, by way of clarification, I think the order that's coming up will also not be the final order, because it won't be the final order in this entire action, only as to the release of the wrongful lien.
Correct.
Okay.
Correct.
Okay.
Correct. We are on the same page there. Yes. All right.
Your Honor, so that I do not run afoul of the court, if I file a lis pendens in this action and record it with the county, will that be something that would be prohibited under subsection 4?
You're looking at 38-9-205 subsection 4?
No, I'm looking at 4 on this
You're looking
interim
at the order. Okay, let me make it clear here. Respondents and its agents, representatives of science, and any other parties acting on behalf of said parties are hereby prohibited from recording any further documents against the subject party without first seeking and obtaining permission to do so from the court of competent jurisdiction. And so, yes, that's anything else that would be recorded against the property by the parties here would be falling under the scope of paragraph 4.
The problem is, Your Honor, is that I can't file a lis pendens. That's not a motion. That's a notice of an interest pursuant to a legal action. There's a legal action that was instituted by the petitioner here related to this property. And if the court goes ahead and enters that order under sub 4, that would hamstring us because, as the court noted, there is a check. It was signed. And there is money that was used against this property. And if the court says that we can't file a lis pendens, then there's nothing stopping Ms. Jones from stepping outside the courthouse today and transferring that property to anybody else.
I want to emphasize something that is in the language of that, without first seeking and obtaining permission from the court to do so. So I don't have a motion before me about a lis pendens. I don't have anything about that. And so what I have here is telling the parties that they cannot file any other with any other recordings against this property without first seeking and obtaining permission from the court to do so. I would have to be satisfied that there would be grounds to do so. Mr. McDonald, I see that you want to be heard on this. Go ahead.
Your Honor, I don't know if this would matter, and this may be outside the court's purview because, again, if we're only supposed to deal with the wrongfulness of the lien.
Correct.
Okay. But there's been much made of the $225,000. I was going to be filing a motion asking for it to be interpleaded into the court's account. Maybe if we're done with this hearing, we could have a 2-minute hearing allowing me to verbally make that motion. If we're allowed to do that, that would obviate the concern expressed by counsel that that money is at risk, because then it would be within the purview of the court to give it to whomever you like.
All right. Mr. Beckett, do you want to be heard on that? And so, again, what I want to make clear of is paragraph 4 indicates that there could be reasons that I would allow the parties to file other claims or other documents against the property. It's just that it needs to be with permission of the court. What I'm hearing from the petitioner is that more is wanting to be done here to address the concerns about the pertinent money that's been talked about here.
No, Your Honor, my client wants the property. They entered into a contract to buy a piece of property. And just because the value of that property is increased doesn't mean that they don't deserve the benefit of their bargain. And so if they're interpleading the money to the courthouse, that doesn't resolve the problem, and the interest is in the property.
All right. The parties are talking over each other, past each other, and so this is what I'm going to say. I don't have a motion before me to put a lien on that. What I'm going to do is I'm going to sign this order that says paragraph 4, I expect the parties to comply with. And if there's some sort of motion before me that indicates that there should be another, that there should be something recorded against this property, then I'll look for a motion for that. But I don't have another motion for that. What I have is petitioner's motion, which I've granted, which is indicating that the current notice of intent is a wrongful lien. the current notice here, I have indicated I don't have anything else before me, and part of the relief I'm granting is that there shall not be any documents, any further documents recorded against the property without first seeking permission from the court to do so.
Then I'll make an oral motion to the court to allow us to file a notice of interest against the property that reflects that the notice of interest is protected by the check that was signed by Holly Jones.
And I'll have you file a written motion about that, not just an oral motion. You can file a written motion, and Mr. McDonald can respond to that, but I'm not going to consider the oral motion today.
Your Honor, you're cutting our legs out from underneath of us, because now Ms. Jones can go out and transfer that property this minute. And then I would ask that the court go ahead and wait to file this for 7 days so that we would have an opportunity to brief that issue and to ask the court for an opportunity to make sure that we can protect the interest in that property.
And again, this is where there is still 4B. And that's why I asked the parties to notice here that the court is looking at Utah Code 389-205 4B. The court may not determine any other property or legal rights of the properties or restrict other legal remedies of any party. I'm not restricting you seeking legal remedies here. I want to make it clear to the respondent, Mr. Beckett, I'm not limiting the motions that you can file here, the grounds that you want to file them on. What is before me is the sole issue of whether or not the current notice of intent is a wrongful lien, and I've given my ruling on that it is. And part of the order here that I'm giving is that there shall not be any other documents filed against the subject property without leave from the court to do so. And I think I've ruled on this issue. If you're going to motion up something that you want permission from the court, then I'll look for a motion from you, Mr. Beckett, and Mr. McDonald can respond to that.
Unfortunately, under subsection 4 here, Your Honor, you did unwittingly move into sub 4B, where you did restrict our ability and our interest in the property by saying that the only way that we can actually file any interest in this property is by coming to the court for help. And the court has already said that the check, because it wasn't referred to or the notice of interest didn't refer to the check, and it is effectively insufficient, that we can't then go and remedy that by filing a notice of interest by saying that we actually do have an interest in this property, because the court actually is now saying you don't have an interest in the property by its order under sub 4, because you're saying we cannot
what I'm saying is that current notice of intent is a wrongful lien, and that other Mr. Beckett, you're putting words in my mouth I didn't say. What I said was the notice of intent is a wrongful lien, and no other documents shall be filed against the property without permission from the court. That is what I said. And so at this point, I think I've indicated what I said on this, and I'm going to move on here. I'm going to sign this order because it properly reflects what I've ruled here. Mr. McDonald, I'll give you. Would you like to respond to anything that's been said? I want to be careful and give both sides here an opportunity to respond to some of the arguments that have been raised here.
No, Your Honor. I think that's all I have. Would it be possible to get a certified copy of the order?
Yeah, if you'll hold on, please. The first thing I'm going to do is sign and date this. So today is the 18th of May. And I have just signed the order that has been given to me, reflecting my ruling here, the petition to nullify a lien. So I'm going to look at my clerk here who's helping me. There is a request for a certified order. Is there any way that this can be given, a certified copy of this to me?
Normally, if they're going to put to record it, we might want to scan it and give him the original.
Let me just highlight. We are short on staff, and so my clerks are
I'm happy to wait.
I'm wanting to be sensitive to the fact that my clerks are needing a little bit extra time because we are short on staff. So
it'll meet me downstairs after the hearing.
Yes, certainly we'll do that.
Okay. Mr. McDonald, you recognize I am asking that you prepare an order that reflects my rulings here today and for my signature. So, excuse me, do you have any questions for me?
No, Your Honor. Thank you.
Okay. Let me make sure that I've addressed the questions before we conclude. Mr. Beckett, any other questions at this time?
No, I'll just provide notice to the court that a notice of appeal will be filed today.
Oh, okay. Understand that. All right. With that, again, thank you for your arguments, counsel. And both of these matters that were set before the court today have been concluded, and court is in recess. Thank you, everyone.